what did you guys figure out?
All right, good afternoon, everyone. This is the afternoon docket. On the first appearance, we have first Tierra Stewart.
Do you care though what time you come down? It's different
She's here,
from
President Judge
7:30.
Emmett. She's approaching. Come on up, ma'am.
You have to stay here with her.
All right, Ms. Stewart, you are before the court. Charge one is DUI, alcohol or drugs, and number two is DUI with a breath level greater than .15. I do find probable
If she wants
cause.
to, what do you care?
Judge, and speaking of Ms. Stewart, I know she reached out to her mother yesterday, or earlier, much earlier today, to see if she can post her bond. And unfortunately, I didn't see in the system when her bond was posted, so I know Ms. Stewart thinks that her mom's having problems coming up with that monetary amount. Now, my understanding is Ms. Stewart has a very, very limited contact with the system. I believe maybe one prior misdemeanor petty theft that may have been dropped or something like that. But she's been here her whole entire life. She's 30 years old. She's working. She works for United Transactions, that company. She's been for 1 year. She's a single mom raising her two children. She lives in Miami Gardens along with her children with her mother. So, Judge, she says she will be coming back to court. I'm going to be asking for the court to consider releasing her on pretrial release.
All right, I'll release her to pretrial with no alcohol or intoxicants.
This is the map and location of pretrial. You have to report there within 24 hours. If not, a warrant will be issued for your arrest.
All right, thank you.
Good luck, ma'am.
Christine Ken May. Ken May's bond has been
Oh,
posted.
bonded, Judge.
All right. Heather Gerasi.
North Broward.
All right, Mr. Rossi, you're before the court. Charge one is possession of cocaine, and number two is disorderly intoxication. And I find probable cause for those charges.
Judge, this is an extremely small amount of cocaine. Not that that makes it legal, but I think it certainly is an indication that she wasn't in possession of very much. I don't know what the state attorney's office is ultimately going to do. My understanding from speaking with Ms. Gerasi is that she has two prior DUIs, and I think that, if I understood her correctly, that was the extent of her criminal history. She's been living here for 10 years. She's been living in the same place for a year. She lives with her boyfriend. She babysits. She makes about $200 a week. I was wondering if the court would consider releasing her on her own recognizance.
Your Honor, the state would object to a straight ROR, considering the allegations that whether it was alcohol influence or drug influence, she somehow made her way to the kitchen of this restaurant and took a knife and caused some of the employees some concern. And she does have prior DUIs out of Ohio and Kentucky. Let's
All
see,
right, I'll release Ms. Gerasi to pretrial supervision.
Judge, I think instead of that, her boyfriend will assist in getting her bond money together. I'd ask you to leave it at $1,000.
So why did we ask for ROR? Oh, because we don't want to be on pretrial.
That's right.
That's
So I see a DUI out of Mississippi. And at least a DUI arrest out of Dade in 2013.
no, I think I'm gonna go with my initial. There's ROR to pretrial with random drug testing. Okay. Those are your release conditions, ma'am. You need to report to the pretrial office by tomorrow morning. If you don't report, a warrant will be issued for your arrest, and you'll also be subjected to random drug testing.
All right, Heather, make sure you show up there tomorrow, okay?
It's on What time? Okay.
They open at 9, so you need to be there. Yes, ma'am. Okay,
Okay.
all right.
Good luck, Heather.
Sabrina Moore.
She's a medical reset, John.
All right, Ms. Moore is a medical reset. Rodolfo Ponce de Leon.
He is here, Judge. He's here at Maine. Come on up, Mr. Ponce de Leon. He's approaching, Judge.
All right, sir, you're before the court for driving while license suspended, and I find probable cause. Does Mr. Ponce de Leon have any criminal history?
I'm not showing anything, Judge.
Okay.
Judge, the only 2 days. Hold on, Judge. The only thing I will say, Mr. Ponce de Leon's behalf is, he advised me he's been saving up. I believe his driver's license suspended due to tickets and speeding. He paid off, I believe, in June about $500 to get his license fixed. So he's taking steps, considering his lack of any major criminal record. I'm asking if the court would consider an ROR. If not, he did give me the phone number of his father, and I will be calling him after court to post his monetary
All
bond.
right, I'll grant the ROR, okay?
Thank you, Judge.
All right, Donald King.
Mr. King is approaching, Judge. Come on up, Mr. King.
Is this a reset from this morning? This one? Okay. All right, Mr. King is before the court for charge 1 is DUI, alcohol or drugs. Second offense, number 2 is DUI with damage to property or person of another. Number 3 is DUI with a breath level greater than .15. And number 4 is failure to use due care. Okay, and I find probable cause.
Judge, in speaking, Mr. King, I gave him a whole bunch of options which I could request, but I believe the option that he wanted me to do is just to ask the court for a property order so he can have access to his wallet. He has phone numbers in there of his family and friends that could post his bond. So per Mr. King's instructions, that's what I'm requesting for at this time.
All right, so I'll sign that order and I'll leave the standard bonds in place. All right, Jerry Edwards.
Mr. Edwards, bonded, Judge.
Mr. Edwards bonded. Jesus Fernandez Astacio.
He's here, Judge.
All right, Mr. Astacio is before the court for 1 charge of touch or strike battery, and I find probable cause.
Judge, Mr. Fernandez is requesting if the court would consider releasing him on pretrial release.
State would object. I'm showing Mr. Fernandez Estacio. Well, first of all, I think he was just before the court yesterday. He was arrested August 6th on a municipal ordinance for open container. He pleaded out to time served, was released on the 7th. And I'm showing that he also has an open failure to pay a restaurant, an open misdemeanor case with 3 counts of criminal mischief, 1 count of carrying concealed weapon, and a 3rd case, open case, criminal mischief carrying concealed weapon.
And the allegations in this probable cause affidavit is a little bit concerning that the report says that he unexpectedly struck the victim, and then when she fell to the floor, he continued punching her in her facial area, and this is the waitress at this place. So I find probable cause. I am going to leave the bond at $1,000, no victim contact, and no return to that location. Okay. John Preston Gilmore,
No problem, John.
North Broward. All right, Mr. Gilmore, you are before the court for a misdemeanor capias.
I don't know if I had a cape and I had no address. I'm on the street from Ohio, Detroit. I fell asleep on the property, didn't know where I was. I don't have no family here. All my family's in Cleveland, Ohio, Detroit, and Chicago. I'm the only one down here. So I'm homeless with nothing.
Well, sir, if if you don't have an address, that's not, something that the, clerk's office has any control over. They're gonna mail it to the address that you gave them. And if you don't have an address, or you no longer live at the address that you previously provided, then you have a responsibility to check with the clerk's office to see when you have to go to court. It can't be someone else's, problem. It has to be your problem.
I just buried my sister from suicide, okay? I'm dealing with,
I don't know how you don't have any family here and you live on the
I
street.
don't.
But then you're
I'm not
dealing with
from
your,
Florida.
yeah, okay. All right, what do you want to do?
I want to resolve this today.
All right, well, and maybe you need to change your attitude just a little bit.
I'm not mad at you. I'm mad at them piece of shit. Excuse my language. I'm mad at them cops who put. Never mind.
You may want to come back tomorrow to resolve this matter.
No.
Oh,
I'm
I am
this.
not, we're not going to, I'm not gonna tolerate, your attitude this afternoon, okay? You gave an address for West Palm Beach, you no longer live there,
I never did stay there.
well, it is your responsibility to let them know where you are and how to find
just-
you, okay? So for you to come before this court this afternoon with an attitude and cursing, that's not going to help
Hey,
you.
ma'am, I'm 48 years old. I just buried my sister. She committed suicide. All right? I'm not mad at you. I just want to get this over with so I can make arrangements to go home and bury my sister. That's all.
All right, Mr. Gilmore, what plea do you wish to enter? I am going to sentence you to adjudication and time served.
You're guilty.
All right, well then, I need you to raise your hand. We're gonna go through the plea colloquy. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever
No.
been treated for mental or emotional illness?
Mental. I get disability.
And is there anything about that illness today that would prevent you from making a decision?
No.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yeah.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yeah.
You have two options. You have two options. You can choose one. You can enter a plea of guilty or no contest. Which one do you wish to enter?
Guilty. I was sleeping. I mean, I
All
know
right.
I mean,
I accept your guilty plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Okay? All right. Eric Overland.
Judge, I've been informed Eric Overland bonded.
Mr. Overland bonded. Tommy German.
Tommy German.
German.
Mr. German? No? Oh. One more, Judge.
He's sleeping.
He's coming, Judge, he's coming.
The whole much.
Please help me come to jail and get it in. It's on down the street. Right here, they wait.
All right, Mr. German, you are before the court this afternoon for 2 municipal ordinance violations. Trespassing and resisting without violence. Okay?
Just resisting the violence.
Yes, sir.
Press on for it. Do you work?
Mr. German, what do you wish to do today?
What can I do?
Well, you can post your bond, or you can resolve the matter today.
I would like to resolve the matter today, ma'am.
Okay. All right, if you want to resolve your case today, you will be sentenced to adjudication and time served.
Thank you, ma'am.
Well, please raise your right hand so we can go through the plea colloquy. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. German, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes. Yes, ma'am.
All right, what plea do you wish to enter, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. And I'm going to tell you no return to that location, sir. Do you understand that?
Yes, ma'am.
All right. You've been trespassed before, so you know, no return. All right,
Okay.
okay. Ballard Moody.
Medical reset.
Mr. Moody's a medical reset. And then Maurice Lewis.
North Broward.
And Mr. Lewis is before the court. The charge is possession with intent to sell, manufacture, or deliver cannabis. And the court does find probable cause.
Judge, Mr. Lewis indicated his family is going to be bonding him out.
His family is bonding him out.
Yes. I'm going to call his dad after court to make sure of that. In fact, maybe we could check if confinement status would be kind enough to look to see if his bond has been posted yet.
Okay. Okay. All right, it's not showing as posted. He has $1,000 bond. Okay. Darren Green.
He's approaching judges here, man. Come on up, sir.
Yes, ma'am.
All right, Mr. Green, you're before the court for attempted first-degree murder. And number 2 is possession of weapon or ammo by a convicted felon. I do find probable cause.
Your Honor, the state would be seeking a no bond hold on Mr. Green upon a finding of proof evident or presumption great for first appearance purposes only. Noting Mr. Green was according to the arrest warrant affidavit, the detailed arrest warrant affidavit, Mr. Green was identified by the victim. He was caught on surveillance video following the victim, firing numerous shots at the alleged victim. There's statements given by numerous witnesses describing the subject, Mr. Green, the subject seen on surveillance video firing at the victim multiple times. As far as his intent, according to the victim, Mr. Green made a statement threatening to kill him. There was not just one shot fired, but multiple shots fired at the victim. This is also corroborated by the surveillance video and statements made by the witnesses hearing multiple shots fired.
Okay.
We would object to the court making a finding of proof evident presumption great at this stage of the proceedings. That's the highest standard of proof that we have in the criminal justice system. I have reviewed the arrest report, probable cause affidavit, and so forth in the case. I would argue that the state has not met that very high burden of proof evident presumption great. Ask the court to set a bond for Mr. Green. In the alternative, if the court over our objection does find proof evident presumption great, I would ask you to exercise your discretion and set bond for Mr. Green.
Okay, I have reviewed the affidavit to arrest, which is, pretty detailed, as to what occurred. And so based on that, I do find probable cause. I am making a further preliminary finding of proof evident presumption great. And, this is without prejudice, for Mr. Green to have a bond hearing before his division judge. He will be held no bond until such time.
Judge, I
Well,
believe
Your
on
Honor,
count-
And then, yes,
Mr. Lundey will
whatever
bring
the
it up.
court wishes, whatever bond the court wishes to set on count two, I'm fine with.
okay.
And
Was there something you wanted to say in regards to the bond, Mr. Romero?
No, Judge, not at this time.
Okay.
And the only other thing, I apologize if the court already ordered it, but just in an abundance of caution, request no contact.
I'm sorry, oh.
Peers are known to, the subjects are known to one another.
All right, sir, no victim contact. If you post your, well, if bond is given at a later time, I guess that your division judge will deal with that. But at this time, no victim contact, meaning no phone calls, no text messages, no social media, no third-party contact. And as to count two, I am going to impose a $5,000 bond on that count, okay? All right. And then Lavaro Stigner,
Mr. Tigner's approaching, Judge. And after Mr. Tigner, Judge, I believe before Mr. Green on my docket was Mr. Eduardo Bermudez Vargas. He was the gentleman that was reset from this morning.
I don't have that, I have. Is that true that we had,
I believe
I
of the
didn't-
conversation, he had a burglary and then I believe confinement status, or somebody was saying that there was gonna be a parole violation, then they said we will see him this afternoon.
That was, I thought that was Lamar Anderson. I mean,
no,
granted, we don't,
I have Lamar Anderson,
Oh, that was LeVar Anderson?
yeah,
Okay.
so,
because count one, yeah, because count one
Lam-
is a disorderly conduct,
Right.
but count two, which wasn't on the booking sheet, it's actually a probation violation.
okay.
I'll let the deputy
Right,
know that.
right,
that's
it's
state
Lamar
officer,
Anderson,
Mr.
yes.
Bermudez.
All right, so, Mr. Tigner, you are before the court on aggravated assault with a deadly weapon without intent to kill is number one. Number two is the same thing. Number three is false report, of, a bomb explosive or weapon, charge, okay? False report concerning the use of firearm in a violent manner. That makes more sense. Okay, and I find probable cause.
Judge, and speaking of Mr. Tigner, there's no way he's gonna be able to come up with the $60,000 bond, which is currently set. Judge, right now, he is scheduled to start work this coming Monday. He just got a job working at UPS, where he's gonna be making approximately $13 an hour. Now, he's been here his whole life. He's 21 years old. He lives with his grandmother. My understanding is his grandmother's on Social Security. He's also gonna be reaching out to the mother of his children. The mother of his children, however, is working right now 2 jobs, one at McDonald's and one at a retail store. So her financial funds are limited. And he also, from what he advised me, he needs to be out in order to help basically raise his 2 children and take care of his grandmother. My understanding is, like I said, he can't come up with the $60,000. I'm asking at this time if the court would consider reducing the bond on count 1 to $10,000, the bond on count 2 to $10,000, the bond on 3 to $5,000, which we would be requesting a total of $25,000 bond on Mr. Tigner's behalf.
Your Honor, I'm gonna request that the court keep the bonds that Judge Fine set in place. Considering the allegations, I think they're reasonable. Allegedly, and it's captured on video and there's witnesses, Mr. Tigner entered a McDonald's, threatened not only to kill, armed with a firearm, displayed the firearm and threatened not only to kill the victim, but to shoot up the entire McDonald's, and there were customers and employees present. Your Honor, in addition to this, his criminal history, He was arrested for domestic violence battery in 2016. That was dropped. He was convicted of a battery and theft in 2016. He violated probation. And as a juvenile, he has priors for kidnapping, battery, disorderly conduct, another battery. In addition to the bond, Your Honor, the state would be requesting pretrial release of the GPS monitor. No victim contact, no return to the location of this McDonald's, no possession of any firearms, weapons, or ammunition.
Judge, the only thing that Mr. Tigner wishes to basically dispute was the allegation as far as prior juvenile kidnapping offense, Judge.
Your Honor, it's either a kidnapping or a false imprisonment. It's showing kidnapping, but it could be a false imprisonment.
All right. So based on these allegations, there is, it's, there's a threat to an individual victim and, and then another threat into the McDonald's where there were other people sitting with a gun, allegedly saying that he's gonna shoot up the place. The court does have great cause for concern for the community. And the allegations not only come from the individual witness, but also from the employee at McDonald's. So I am going to leave these bonds in place, finding probable cause, and if Mr. Tigner posts his bond, he is going to be on an ankle monitor pretrial supervision, level 2. Okay? No victim contact.
Sir, come on, sorry.
No victim contact. That means no phone call, no text messages, no social media, no third party, and also no return to that McDonald's, okay?
And Your Honor, only other thing we'd
No
ask.
weapons or firearms,
Thank you, nothing further.
okay? Okay, Eddie Gaspard.
He's approaching, Judge, here, me. Come on up, sir.
Mr. Gaspard is before the court on charge 1, possession of THC. Number 2, possession of drug paraphernalia. Number 3, attaching license plate not assigned. Number 4, expired tag. Number 5, failure to provide proof of insurance. And number 6, felony violation of probation, which has a no bond hold, and you see your division judge tomorrow. I find probable cause. And I will leave the bond in place on the other count.
Good luck, sir.
Lamar Anderson, then?
Judge, I'm sorry,
No
one
power,
request of phone,
Judge.
Sure.
please.
I'm sorry?
A phone order for Mr. Gaspard?
Sure.
Thank you.
North Broward? All right, Mr. Anderson, you're before the court today, disorderly conduct, and number 2 is a felony violation of probation, which is a no bond hold, okay? I find probable cause, and the information I have says that you see your felony judge on August 16th, okay? So, and I'll leave the other bond in place. Okay, sir. All right, I guess let's start with the felony docket, since that's on top. Philip Batchelor.
This is a motion to release, Your Honor. The
Yes.
state has not yet filed an information. Mr. Batchelor is entitled to an ROR at this time.
All right, Mr. Batchelor, the state has not yet formally filed the charges, and so you are entitled to a release on your own recognizance. I will sign that order. Sir, these are, well, they're felony, the felony charges. The state still has time to file those, so you need to make sure that you check with your attorney if you have one, or check online, or check your mail to see if you have to come back to court, okay?
Yes, Your Honor.
All right, good luck, sir.
Thank you.
Robert Sissel?
So I'm being released.
Where do we have Mr. Sissel? Robert?
I think, he's just stood up.
He's here at me, Judge.
Oh, okay. All right, so this is a second look for Mr. Sissel, correct?
Yes, ma'am.
Yes, Judge.
And let's see what I have. So Mr. Sissel has $1,000 bond currently, and all right, this for theft. And resisting, you refuse to stop,
Michelle.
jumped a fence into someone
Was
else's
put on
yard.
Pretrial on a felony case.
The total value of the items,
in June that ended up being
$1,334.
dropped. I need to know if he ever showed up.
Judge, Mr. Sissel advised me that he is working. But right now, as you can see, no one can afford to post his bond. He does have a place to stay where he can reside. So we're gonna be asking if the court will consider, I believe we asked initially for a pretrial. The court was not inclined for pretrial. So at this time, that's why we're asking for the court to consider level 2, pretrial on Mr. Sissel's behalf. My understanding is, he has a place to stay and where he's gonna be staying at. He's eventually gonna be going to the Broward House because some of the services that they provide, he's in need of. But right now, he does have an address, is what Mr. Sissel is advising me, Judge.
Speaker.
Yeah, you
That's
can
the
speak, of course,
7556
Your Honor.
CF10A.
but not about the facts.
Your Honor, here's the issue.
Hold on.
Sorry.
Go ahead, Mr. Sissel.
Yes, ma'am. Your Honor, I've been working on this, going to this place for like over a week. It's involved with SunServe out of, Wilton Manors, and it's also involved with the Broward House. It's an HIV clinic, which I really need to get myself stable. I have a big rash, serious stuff going on right here. They're willing to fast track me into the place as a courtesy because of my sickness, and that's what I've been working on.
Okay.
Here's the issue. It would appear, Your Honor, the court in June of this year, when Mr. Sissel appeared before you, really gave him the benefit of the doubt, because he was arrested on a possession of cocaine and paraphernalia and multiple cases for failures to appear. You released him to pretrial on the cocaine and ROR'd him on the misdemeanors. Now, the cocaine ultimately was dropped. The problem is, and I just confirmed this with pretrial, he never showed up to pretrial. If the case is filed, I imagine they would have had a warrant signed by, or brought a warrant to his judge. But the concern being, when he was given the opportunity to go on pretrial, he didn't do anything about it.
Thing was, Your Honor, they dropped all those charges.
Right, but you didn't show up when you were released.
They were dropped.
I went to pretrial religiously.
Tell me no. Religiously?
Now, I can't argue the facts, but I know I went.
All right, Mr. Sissel, I am going to leave your bond at $1,000. You're saying you went and pretrial is over, you're telling me you never showed up. And I understand that the charges were dropped, but they were not dropped before you were supposed to report, okay? All right. Dalkeith Morris,
Mr. Morris is here present, Judge Amain. Come on up, sir.
Mr. Morris is here for a second look at his bond status. He has $1,600 total in bond. And I kept the bonds in place on August 6th, so what's going on here today?
Judge, I know, I believe I did ask for the court to release Mr. Morris on pretrial, and I believe after the state talked about his priors, the court was not inclined. However, he's still not, he lives with his mom, he has an address, he's working in construction, been with the same company for 8 years. He's been here his whole life. Now, Mr. Morris is looking forward to his day in court. My understanding, and speaking to Mr. Morris, he was not the driver. It was somebody else. That person ran off, so he's wanting to contest these allegations. It wasn't him that was driving the vehicle. But having said that, Judge, I did tell Mr. Morris this isn't the time or place, but he wanted me to let the court know this. But right now, there's no one that can post his bond. He's wanting to be supervised, Judge.
All right, so
Your Honor, if I could just have one moment.
there's a crash per the probable cause affidavit. A single vehicle accident. And the officer waited for additional backup unit to make contact with the vehicle. I observed a black male, the sole occupant of the vehicle, crawl out of the passenger side front door and detained him without incident. He had the powder from the airbag deployment on his ear. So,
My understanding is the officer didn't arrive instantaneous upon the crash. There was some time that elapsed, and he saw Mr. Morris exiting and didn't see the driver exiting. And that's what he wanted me to inform the court, Judge, but he just can't afford this bond. He's willing to do level 2 pretrial.
The officer notes, and I know Your Honor has already seen this, that he was on the scene almost immediately after he heard the crash.
all right, sometimes it's probably better not to say anything until it's the time to say something. So I am gonna leave the bonds in place at this time. Okay? All right, on the misdemeanor docket, Kevin Shaw,
No problem.
He's in North Broward, Judge, and he's also on the following page. And I think he may have bonded out on both of these cases already. There's a hold out of him from Key West.
oh, is that correct? He's already bonded on these two cases?
That's correct. The only thing is no one here.
All right, so we have nothing to do here today, Mr. Shaw, because on the cases that is in Broward, you've already posted your bond on those. The matter is that you've got a hold from another county, okay?
Okay, how long would it take for me to transfer?
That I don't know. It's up to-
Sir, they can't really give that information out for security reasons at this point.
Right,
Okay.
all right?
No problem.
Okay, good luck, Kevin.
All right, Sentinel.
Heath King,
Conti, Your Honor.
or Mr. King was arrested on August 5th. And this is a petty theft charge. And he has a $25 bond.
Man, it would appear that there was some, I suspect some strategy employed in picking this item. The allegation is he picked a DeWalt power drill and stole it from a Home Depot, value of $299.99. One moment, Your Honor. He was arrested. Just want to see what was going on with that case. He was arrested a few days prior to this. It's trespassing.
He already pled out the prior arrest.
Yeah, yes, Your Honor. What happened was, I just want to see where he's allegedly trespassed. Okay. Yeah, he was arrested July 30th at a Pollo Tropical, where he and a co-defendant were being very aggressive with patrons. He was hit with a 94806 VOP violation, but we determined at his first appearance that it had already been, the probation had been terminated upon completion of a jail sentence.
Okay,
So, Your Honor, found no PC for the 94806.
okay.
He pled out for adjudication time served and was released, I believe, on the 30th or 31st, and now he's back 5 days later. On the original VOP, which was for, it was a 2017, 4 counts of dealing in stolen property, 3 counts of false ownership info and a pawn item. Trying to see when he was released on his VOP for that. He was just released June 26th of this year for that. The state's offer at this point would be, if he wants to resolve it, it would be 10 days county jail, credit for time served.
That actually was what I was going to extend to him if he wanted to resolve.
Great
So,
minds.
Mr. King, do you wish to accept that?
I do.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, sir, you can put your hand down. And so, Mr. King, you understand the offer that has been extended to you?
Yes, ma'am.
And is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
I do not.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I do.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is 10 days adjudication, 10 days in the Broward County Jail with credit for time served. Okay?
Yes, ma'am.
All right, David Odak.
He's approaching, Judge. He's here at Maine. Come on up, Mr. Odak.
All right, if I remember correctly, Mr. Odak was here. He was offered 5 days. And I think he quickly shook his head no. And he's still here on a $25 bond.
That is correct, Your Honor, and the initial offer of 5 days is still on the table if Mr. Odak wishes to accept it.
I'll take it if I must, but Your Honor, my mother's in her second bout of lung cancer, and I tried to speak with her on the phone last night. She's not doing well. Her husband just had a stroke, and I really need to get home to her.
Well, I don't want you to take anything because you must, so, what was, Mr. Odak's, history?
See, and that's the thing. Mr. Odak was just arrested July 29th on a failure to appear capious on a theft. He pled that out April 25th. And this, he's had multiple priors for this offense. And I understand what he's saying, but it just doesn't coincide with someone that at
So in
7
less
o'clock
than
in-
5 days, July 29th, and then
yeah,
he's back again on August 5th.
that is correct.
And it just doesn't add up what you're saying at this time. I'm gonna leave your bond at where it is, okay? All right.
Take the whip.
Samuel Renshaw.
She wouldn't do it.
Mr. Renshaw was arrested on August 5th, and
Judge, Judge, he's the gentleman that I initially asked if the court would, if the state had a plea offer. I believe the state did not have a plea offer and we left the bond in place. I'm asking once again if the state does have a plea offer this time. If they don't have a plea offer, Judge, I'm asking at this time if the court will consider releasing him on pretrial release.
And,
Doing is passed out in front of a plaza.
this doesn't make sense. Just one moment, Your Honor. How does Odyssey not have any? Your Honor, I don't have an offer, and the issue is, this is just, it's ongoing similar type behavior for Mr. Renshaw. He's was out on an ROR from a June 10th arrest for disorderly conduct. He was charged resisting with violence. The state filed it as resisting without violence. That occurred at Memorial South when allegedly he was trying to fight with officers. It says he was being discharged. He was hostile, unruly.
Has he resolved that case already?
No, it's still, it was just downfiled to a misdemeanor. The clerk's office, it was filed August 1st. The clerk's office needs to schedule him for an arraignment. He's threatening medical staff, yelling obscenities.
All right. Mr. Renshaw has been in 4 days. If he wishes to resolve the case, I'll give him 5 days with credit for time served.
He wishes to accept the charge.
All right, and just understand that this is only on this case. Apparently, there's another pending matter, okay? All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Renshaw, do you understand everything? You can put your hand down. You understand everything that we've discussed here today?
Yes, ma'am, I do understand.
And is anyone forcing you to resolve your case?
No, they're not.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, I do not.
Sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
I do.
Have you ever been treated for mental or emotional illness?
No, I have not.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, I do, ma'am.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, 5 days, Broward County Jail, with credit for time served. Okay? Kevin Shaw.
He bonded.
Oh, that's right. I did know that. All right, I believe we are at the end of our afternoon docket. Thank you, everyone. I will see everybody tomorrow.